Good morning. My name is Brian Moulton. I'm legal director here at Human Rights Campaign. And as you heard from Fred in the introduction, we now have more than 50 marriage cases in state and federal courts all over the country. I have the great pleasure this morning of moderating a panel of attorneys and plaintiffs from a number of those cases, including all of those that are currently pending before federal appeals courts. So I'm going to start by quickly introducing our large panel, and then do a series of questions to each of them, and then we'll turn to all you for your questions from the audience. So starting at the far end of the table, practically, Scott Circle over there, is Chantal Feibeck, who is an associate in the litigation department of the DC office of Gibson, Dunn & Crutcher. Chantal is counsel in Bostock v. Rainey, challenging Virginia's marriage ban, supported by American Foundation for Equal Rights. In addition, we have representatives from the ACLU and Lambda Legal on the panel, who are counsel in a class action that is also part of the appeal in the Virginia marriage case. Second are Mark Ferris and Vic Holmes, who are plaintiffs in DeLeon versus Perry, challenging the Texas marriage ban. Mark is a practicing attorney and Vic a retired Air Force officer. They've been together for more than 17 years and filed suit last October after they were denied a marriage license. Next to Mark and Vic is Shannon Fowler. Shannon is a partner in the Fowler Law Office in Louisville, Kentucky, and counsel in Burke versus Bashir, challenging Kentucky's marriage ban. Shannon is also counsel in a case challenging Indiana's marriage ban. Next to Shannon is Ken Mogul. Ken is a partner in the firm of Mogul, Posner & Cohen in Lake Orion, Michigan, and counsel in DeBoer versus Snyder, challenging Michigan's marriage ban. To my left is James Essex, director of ACLU's Lesbian, Gay, Bisexual, Transgender, and AIDS project in New York. James is counsel in Obergefell versus Wimislow, thank you, challenging Ohio's marriage ban, as well as I noted earlier in the challenge to the Virginia marriage ban, and the ACLU is involved in a number of other marriage cases. To James's left is Dan Cannon, a founding member of the law firm of Clay Daniel Walton Adams in Louisville, Kentucky, and counsel in Love versus Pence. That's a nice name. And finally is Shannon Mentor, legal director for the National Center for Lesbian Rights, and counsel in Kitchen v. Herbert, which is challenging Utah's marriage ban. Shannon is also counsel in Tanko versus Haslam. It's a case challenging Tennessee's marriage ban, which is also on appeal to the Sixth Circuit. And like ACLU and Lambda, NCLR is involved in a number of other marriage cases across the country. So a very august panel that we have with us this morning. So I'm going to start with a question for Chantal. In a high-profile development earlier this year, we saw Virginia Attorney General Mark Herring end the Commonwealth's defense of the marriage ban and actually support the position of your clients. And Herring is really one of a number of states' attorneys general who have taken similar positions. How do you think that impacted the outcome of your case, the victory that you all had in district court, and what do you think perhaps the broader impact of state attorneys general taking such positions will have when they conclude that these marriage laws are unconstitutional?
Thank you for the question, Brian, and good morning to everyone. Throughout our district court proceedings, we were always confident and optimistic that the district court would rule in our favor given the merits of our case. But we also had the tremendous benefit of the bipartisan legal team of Ted Olson and David Boies, who AFA originally brought together to challenge California's ban on marriage between individuals of the same sex. And so we had the benefit of that going on in our litigation, and we were extremely excited that the district court ruled in our favor. Even with those strengths as we litigated the case, we were very encouraged to have the Attorney General make his brave declaration that he would no longer defend the marriage ban in Virginia. And it's particularly significant in a state like Virginia, where his predecessors had previously elected to defend unconstitutional marriage bans like the ban against interracial marriages, which would have prohibited my own parents' marriage. And they've been married now for 36 years. So it's very exciting to see state attorney generals, particularly in a state like Virginia, make these pronouncements that they will no longer defend these unconstitutional laws. On a broader level, we think that it signifies a couple of things. First, it really highlights the historical moment in time and the change in the legal debate surrounding the constitutionality of these state marriage bans since Ted and David brought the Perry litigation in California. It's been such a fundamental shift. And we're also very optimistic that on a broader level, state attorneys general making these declarations will help all of us achieve a quick and final resolution that will secure marriage equality for all gay and lesbian Americans.
Great, thank you, Chantal. So next I want to turn to our plaintiffs on the panel, Mark and Vic. I wondered if you could share with us a bit about, first of all, what motivated the two of you to file the lawsuit in Texas, and what it has been like to be plaintiffs in the middle of a marriage case in a place like Texas particularly. What's that experience been like, and what are you thinking about as you move up to the next level in the appeals court?
Thanks, Brian. Thanks, everyone. The main reason we did this initially and solely really for me is because I love him. And it's funny, I look back and I see the different interviews that we've done, and I always seem to say the same thing, but I don't really get tired of saying it. So there you have it. But yeah, that was really our biggest motivator. The inherent injustice of not being able to marry the person that you love. We've been told, hey, you could go to a different state, you could go somewhere else and get married, but why should we do that? Why should we leave our home to do the thing that we should be able to do that defines our home?
Yeah, and for us, one of the reasons why we pursue this is, and which is Vic is reluctant to emphasize, but I'm not, is that he's a veteran. He served in the military for almost 23 years, retired as a major, and to some extent we view it as he's earned the right to be able to marry. What's it like for us being as a part of litigation and the opportunity to appeal to the Fifth Circuit? For me as a lawyer, it's a very unique one. First of all, I'm not having to do any work. Secondly, I'm extraordinarily grateful, not just to our law firm that's handling the litigation, Aiken Gump, who's doing a superb job, but I'm really thankful to all the lawyers here and who are not here who have been handling the cases, because the truth of the matter is our success is built upon the successes of others. And it's for a lawyer who knows how much work goes into that, I greatly appreciate it. But I will also say we've been, and then Vic, who is a professor at the University of North Texas in Fort Worth, returned to his class where he teaches medicine and received a standing ovation by his students. It was quite moving for him. We then, after all the madness, we decided that weekend we needed to go to the lake. We have a lake house in Gun Barrel City, Texas. Now, Gun Barrel City is a city of 5,000 people.
It's just what you think.
Yeah, it has a Walmart, and it's in rural Texas.
No Starbucks.
Yeah, there's almost a church for every two people, and it's what was really amazing for us was that all the neighbors came over that weekend, unexpectedly, unannounced, and they all just came over to congratulate us. And
Flash
then
mob block party.
it was fantastic. And the next Sunday, we went to breakfast at the Huddle House, where we, in Gun Barrel City, there's really not a lot to go to anyway. So the Huddle House is where we go for our waffles. And they know us, and the waitresses came running up and squealing, saying that they'd seen us on the news. They actually said that a little too loud from our perspective, because it did get some stares, and thanking us and congratulating us. It was really, it's just been overwhelming. And it's also been a little humbling, because Vic and I realize that we are the face of the litigation along with our co-plaintiffs, Nicole and Cleo in the state of Texas. We're the face of the issue there. And so we're very cognizant every time we give interviews about the importance of trying to change hearts and minds. It's cost me some sleep, worrying about those interviews, trying to make sure that we persuade, because it's not just our lives. We realize it's not just our lives that are affected by this, but it's a lot of other Texans.
And all their kids.
Thank you so much, guys. So next I'm going to turn to Shannon and ask, what your case was one of the first where we had a decision in a case focused on recognition of couples that were married elsewhere but came back home to Kentucky to seek recognition from their home state. And I wanted to ask, what made you choose this path as a strategic decision, and how do you feel now that you have a district court opinion that was very strong? How that will impact folks who I know have now joined the suit, who are Kentuckians who live at home and want to get married at home, as you move forward to the Sixth Circuit.
Okay. First, I want to say Dan Cannon's office is actually on our case too, so we're both doing Kentucky and Indiana cases together. The other attorney in my office and I, Don Elliott, and I, the day that Windsor was decided, we sat down and wanted to know what we could do, because no one was filing suit yet at that point. So we decided that somebody had to do it. Neither one of us has a lot of civil rights litigation, as actually none, but we decided that no one else was doing it, we would try. So we called some people that we knew and that were in other states, and we talked to them, and then we decided that realistically trying to recognize marriages that were already in effect would probably be easier for people to handle, because we didn't know how the judges in Kentucky would react to us trying to let people get married. And we thought that was just maybe a smaller step, instead of trying to go take multiple steps, just take one step at a time, and that would make it easier. Now, Judge Habron's ruling was very clear in the fact that because we didn't ask it, he didn't have to rule on that, but he sounded like he would rule on it. And we then added an intervening complaint so that people that live in Kentucky who want to get married hopefully can get married. So that's going on at the same time. The appeal is with the Sixth Circuit. We are planning on asking the Sixth Circuit to lift the stay, but after the Supreme Court's ruled, I'm not sure how they're going to handle that at this point. But I know from our plaintiffs, the four couples, if you want to look and see what a marriage looks like, they've all been together. Let's see, the shortest is 22 years of all the couples. The longest is 45 years. So to me, if you want to see what a marriage looks like, you look at them. It doesn't matter what gender they are. So this is, to me, and since I'm not married, this is what it looks like, what a marriage is supposed to look like. It doesn't matter what their genders are. And I think for most people in Kentucky, that's why it's easier for them to handle it, because it's like, oh, well, they're just like everybody else. So hopefully that'll work for us in Sixth Circuit too.
Great, thank you. So next I'll turn to Ken. Ken, your case was the first time we'd had a trial again since the Perry case back in California, and a huge focus of that was around the justifications the state has raised to support the marriage ban. We already saw
the witnesses we were able to bring to the court are all highly qualified. The judge found all of them to be highly credible. They represent the overwhelming consensus in the respective professions. The only witnesses that the state was able to put on really were fully exposed. And Judge Friedman's conclusion, as was on the board there, and that applied not just to Regnerus but also to their other witnesses, I would hope would put an end to future attempts to make such claims in future cases. The other thing is that while they were doing this, our very wonderful plaintiffs, April and Jane, who are nurses who adopted 3 special needs children out of Michigan's foster care system, put a human face on the case. And the public awareness of what was going on, the extent to which the local media was following it, the extent to which everyday folks were following it, and seeing this human face with these 2 wonderful, wonderful women who it's an honor to represent, I think had enormous educational value for the public, as well as obviously crystallizing the issues for the court. And it was very important that the judge in our case made such very detailed findings of fact and to support his legal conclusions.
Great, thank you. So next I'll turn to James. James, the ACLU, as I said in the intro, has a role in a number of currently pending cases, as do some of our other colleagues on the panel, and as well as in the cases, the Windsor case, particularly in the Supreme Court this summer. And part of that effort was a strongly coordinated effort to create a diverse body of amici talking about the impacts beyond sort of our traditional conversation around business, religious leaders, elected officials, other civil rights communities. And I wanted to ask what role you see amicus briefs playing in the appeal of the Ohio case to the Sixth Circuit and perhaps beyond to other cases, and what role you think they played in the victories we had last summer and could again as we continue to move forward.
Sure. Thanks, Brian, and hi, everybody. It's great to be here. In terms of friend of the court briefs, I do think that they make a big difference. They're a way to get various different perspectives and voices before the court, whether it's about diving deeper into a particular legal issue or just getting a different voice and a different perspective. And I think the amicus briefs, the friend of the court briefs that have been the most effective have been ones that got unexpected voices before the court. And that includes Republicans, that includes business voices, that includes people of faith, and a bunch of other folks as well. In Windsor, I think there were 45 friend of the court briefs filed. In Perry, there were more. We are working, that is the ACLU plus Gay and Lesbian Advocates and Defenders, Lambda Legal, and the National Center for Lesbian Rights are working together to ensure that a similar range of friend of the court briefs, similar to those that were filed in Windsor and Perry, get filed in all the circuit court cases. That's already happened in the Ninth Circuit. It's already happened in the 10th Circuit. The efforts are underway to get a similar range of briefs, including business briefs, and briefs from Republicans, and briefs from people of faith, and briefs from various different civil rights and other legal experts on a whole range of issues, including parenting stuff, that those get filed in the 4th, where the Virginia case is going to be heard, in the 6th, where there's cases from 4 different states. So I'm confident that that's all going to happen, and I think it's going to make a big difference. It's part of showing to those circuit courts that the country is ready. I also want to just take, since I'm here, with sort of the Ohio hat on, I just want to say just a couple of words about that case. So the Ohio case is the death certificate case. Folks may have remember the story. There was a video that went around last summer. 2 guys, Jim and John, have lived in Ohio for over 20 years, been together for over 20 years. John had ALS, Lou Gehrig's disease, which causes muscular deterioration. It is fatal. It is not curable. When Windsor happened, he was already in hospice care, and they decided that they wanted to get married because they didn't have a whole lot of time left. And so with help from friends and family, they hired a medically equipped plane, flew from Ohio to BWI Airport, not far from here. Didn't get off the plane because he couldn't, but simply by virtue of being on the tarmac in the state of Maryland, they could get married, and they did. They fly back to Ohio and start a lawsuit that is Obergefell versus Winslow, and the whole point of it is simply to say, look, John's going to die. He did die this fall. And when he dies, we want his death certificate, not just for same-sex couples, although obviously we've done a lot of work on that. We brought the Loving versus Virginia case, which got rid of 16 states' bans on interracial marriage. Followed that up in 1970 with the first freedom to marry lawsuit for same-sex couples ever in the country in 1970 in Minnesota. We've been working on the marriage issue through legislation and ballot campaigns and litigation ever since. We were very pleased to be counsel to Edie Windsor in the Supreme Court getting rid of DOMA last summer. And at the moment, the ACLU has 10 freedom to marry lawsuits pending in state and federal court around the country, including Obergefell in the 6th, and representing the Harris class in the Bostic case in the 4th. We are thrilled to be a longstanding part of this movement, especially in this particular moment, and thrilled to be doing it along with all of these amazing advocates and colleagues.
To ask sort of outcome in the Indiana legislature rejecting an effort to amend the Constitution. And quickly on the heels of that, we saw your case and others filed in Indiana. Did that victory, somewhat of a surprising victory in the state legislature, influence your decision to move forward? And do you think that and the legislative victories and electoral victories that we have on marriage in the last several years will have a positive influence on the courts as they're looking at yours and other cases?
Yeah, thank you. And let me apologize for my voice too this morning, but I'm very glad to be here. I think, in terms of what happens at the legislative level when there is something like that is, in Indiana we joke that Indiana's bigots are 10 years behind all the rest of the country's bigots, because this is a constitutional amendment that, you had your map up with all the constitutional amendments before. I mean, these were all enacted in response to Massachusetts 10 years ago, and as a result of Windsor and all these other victories that are happening, judicial victories that are happening, you get the right in Indiana, the extreme right, really in Indiana, raising this constitutional amendment as sort of this fear factor, this bogeyman. And to a certain degree it worked. I think it riled up the left and the right, both in Indiana, and caused some mobilization in a state where you have a Republican governor and a Republican supermajority. As far as how did it influence our decision to file in Indiana, I think it influenced our decision to file very little, in terms of, when they decided to shelve that amendment. That happened very closely on the heels of the Kentucky case. So when we got the opinion from Judge Hayburn, people started coming to us, and I live in Indiana. I've lived there most of my life, and people from Indiana are coming to me saying, "Okay, this happened in Kentucky. Why can't it happen here?" And I was like, "Well, that's a good question." Start researching it, discover that there's one statute in Indiana as opposed to the 2 statutes in Kentucky. There's no constitutional amendment. The constitutional amendment that was proposed is almost exactly word for word the same as the one that we had just defeated in Kentucky. So, I didn't have a good answer for, number one, why should we not file this? And number two, why is there already not an action? We were surprised when we started looking at Indiana that there wasn't already an action filed. So, I think initially there was some fear that the General Assembly was going to come back and renew the idea of this constitutional amendment. And I think that was shelved, and it makes good sense why it was shelved, because any rational thinking person can look at these constitutional amendments now in 2014 and say they're dead on arrival. I mean, it's very obvious that they're dead on arrival. If somebody like Judge Hayburn, who worked for Mitch McConnell and was appointed by Bush once, will issue an opinion that is that strong in Kentucky that says, these are unquestionably unconstitutional. I think even the hard right on a legislature state legislature will start to look at that and say, maybe we ought not to put time and resources into that. But I mean, as a matter of basic civics, the main point of all of our cases is the federal Constitution, the United States Constitution, trumps state law, and it trumps state constitutions. So if they enact a constitutional amendment that says marriage must be between one man and one woman, or any other discriminatory constitutional amendment at the state level, or 100 of them, and 100 statutes that discriminate against the LGBT community, that's fine. There's still a United States Constitution that says, you're entitled to equal protection under the law, and that's how all these cases have been won since Perry. So it doesn't matter how many laws they pass. One thing we know for sure as a result of that debate that happened in Indiana is that the legislature there and in many other states is not going to be a friend to the LGBT community. It's hard to call defeating one of those amendments a victory simply because they're dead on arrival, right? And so it's unfortunate that all that effort has to be put into defeating something that should have been shelved a long time ago. The fact that it was ultimately shelved is a good thing, but we know that there's no friend to the LGBT community on the Indiana legislature, and so redress has got to be sought through the courts, and that's what we've done here.
Great, thank you. So next we'll turn to Susan. As we saw from the timeline in the introduction, Susan, the Nevada case was one that was filed in advance of the cases in the Supreme Court this summer, and you had a decision in November of 2012, which was unfortunately not a win at that time, and yet now we're in a place where the Nevada Attorney General is no longer defending the statute. We've seen all of these significant victories just in the last several months. How and why do you think that landscape has changed so significantly in just a matter of really a year and a half? And do you think that bodes well for all of these cases that are now, including yours, on the way up to appeal?
Thanks. Well, what a difference a year and a half does make. I think as we saw from the data, as we see from the proliferation of lawsuits and wins around the country, and all the colleagues now at this table, it used to be a much smaller table of those who are litigating marriage cases. Well, first of all, the judge in that Nevada case, the Sevick case, really was, the luck of the draw was we got a particularly conservative judge. I think David used the expression, the rightiest of the right. And that, that helps to account for the decision back in November 2012. But since then, the landscape has changed dramatically. The Windsor case was critical, and thank you, ACLU. Was a complete game changer, in so many ways, including in the level of review articulated or essentially plotted out by the Supreme Court for how judges should approach discrimination against same-sex couples. Another really critical thing that happened is that the Ninth Circuit issued a decision, and that, of course, is the circuit we're in, the Smith-Kline decision that said explicitly, we read the Windsor case as demanding heightened scrutiny for any discrimination brought to bear against same-sex couples. Big game changer in the Ninth Circuit, and it should be a big game changer around the country as well, because we expect other courts potentially to be agreeing that indeed is the only way to approach these forms of discrimination. Not that a lower level would defeat these marriage bans. So what we have in the Ninth Circuit now, as we are waiting for our oral argument, which should happen, be scheduled any month now this spring, is that the Ninth Circuit is inevitably going to have to look at Nevada's marriage ban, apply a high level of scrutiny. The state of Nevada, the Attorney General threw up their hands and said, we can't win. We can't win under that high level of scrutiny. And in the last year and a half, we've seen an unbroken chain of, by our count, 14 decisions that have ruled in favor of same-sex couples on the marriage front. That's the wind in our sails when we reach the Ninth Circuit. So we think that the stars have aligned at this point for our case and for others down the line here and others around the country, including a number that Lambda is involved in or leading in other parts of the country as well and in other circuits. I not to make too big a sort of wrap up about Lambda, but we were here 40 years ago at the start of the movement, and we look forward to being here at the end when we have the freedom to marry as well as all other forms of equality for LGBT people. And thanks to so many people in this room and around the country and the stories about the families that are harmed, it is really in sight and really close to that day.
Great, thank you, Susan. And we'll wrap up with Shannon. So Shannon, in your case in Utah, somewhat unexpectedly, the district court did not stay its own decision. And so in December, we had about 1,400 couples marry in Utah. And we've just seen, after the Michigan decision, several hundred couples marry after the trial court decision there until the Sixth Circuit stepped in to stay that. So, now while these states have put pause on marriage in both of these states, sort of what has become of the couples who did get married, and what do you think the reality as the appeals courts consider these cases that there are now folks on the ground in Utah and Michigan who are legally married, have marriage licenses, what influence that's going to have on appeals courts and when they're thinking about these cases?
Yeah, no, I think it's going to make a very big difference. I just want to say it's so great to be here with advocates from all across the country. It's remarkable. I'm just sitting here pinching myself. And I just have to say a special thank you to the Texas plaintiffs. As a native Texan, I really deeply appreciate what you're doing in our state. And I know it's not always easy there. But yeah, Brian, to your question, I mean, there's no question that all those couples in Utah and Michigan, they were married pursuant to a valid, binding federal district court order. There is really no question they are legally married. They're being recognized as legally married by the federal government, by many private employers. And I think this is very significant. They're also the fact that they legally married is being recognized by the state of Utah, and I think that it will also be recognized in Michigan as well. Utah is taking the position that now that the district court's order is, we hope, temporarily stayed while the case is on appeal, that Utah is now free to apply its own anti-recognition laws. So it's not treating them as legally married, but it's not disputing that they are legally married. And I think that is going to be very significant for both the 10th Circuit and the 6th Circuit, and if it comes to it, the Supreme Court. I mean, just from a human point of view and a legal point of view, it is really difficult, in fact, untenable to think about stripping away a couple's marital status once they've been legally married. That would be unprecedented. That has never happened in the history of our country. I do not think it will happen here. It would be devastating for those families and their children, but it would also really undermine the stability and certainty of marriage for everyone, and I hope and believe that the courts will recognize that.
Great, thank you, Shannon, and thank you all for those great answers and great information about your cases. And now I want to take time to turn to our audience for questions. So we'll start with Chris.
Great. One thing that the Obama administration was involved with for this litigation when the Prop 8 no one case came to the Supreme Court, they were filed from the court briefs, or they're actually a party in the no one case. And he also sent the Solicitor General to argue on behalf of the marriage equality side. I just want to get your perspective on whether you think that it's important for the Obama administration to once again speak out as these laws are going forward, and what that participation would look like. This can be more from the court for use, or also arguments within during oral arguments. And James, since you just talked about how important the court for use, I want to know your take first.
Sure. Well, there's no question that the administration's participation in both Windsor, where they had no choice, and Perry, where they did, made a huge difference. I mean, the administration coming out and saying in, I think, February of, was it 12? 11? February 11th. Time flies. Okay, February 11, they say, we can't defend the constitutionality of the Defense of Marriage Act. You know, earthquake in the legal world. That's amazing. An amazing thing for them to stand up and say, okay, the oath that we took to uphold the Constitution of the United States is something we take very seriously, and there is a small universe of context where the Justice Department won't defend the constitutionality of an act of Congress, and this fit into that. No question that had an enormous effect on the district judge in Windsor, on the Second Circuit in Windsor, and I'm sure in the Supreme Court, and in all the other DOMA cases that were pending at the time. I think it was even more remarkable and important for the court, for the administration to come in into Perry and say what they said. And I think it had a big effect on the court. Obviously, the court didn't get to the merits of the marriage question in Perry, but it's obvious to everyone in the room that they're gonna have to get to it. None of us knows which case, none of us knows when they're gonna get it. We can all make our best guesses. They're going to. I think it is very likely that this administration, if the court gets this issue in while this administration is still going, that this administration will file a brief in the Supreme Court. The question in my mind is, are they going to file a brief before then? I certainly hope so. I think a bunch of us will probably ask, and we'll see what happens.
Fred talked at the beginning about sort of a national strategy or a national campaign at 3 different levels. But a lot of the comments that I was hearing from the panel made it seem like all these challenges were more organic. That in Kentucky, saying, how come nobody's filed anything here and doing it, and it's also sort of in Indiana. I don't know who's the best one to comment on this, but to what extent is this organic, and to what extent is this part of a national campaign of an effort to get suits in every state and attack these 3 different levels that Fred talked about in every state?
And now in the Ninth Circuit, the case is, a full-on, full-throated claim for full marriage equality. It is not framed the way those older generations of cases are. So it really does, we think, present the whole issue of the freedom to marry very directly. I think in terms of the fact that there are some cases that are going up on appeal that were confined to recognition of marriages, it's really hard to say what's going to get resolved first, in what order, and there are so many marriage cases going. I mean, Lambda has a number of them around the country, and there are many represented, other organizations and others are doing it. So we can't necessarily control that timing, and nor necessarily, would it be worthwhile, I think, to do so. I think that the marriage recognition cases are very compelling, and we should win on those. But I also, you're seeing, for example, in the Obergefell case, the judge is writing these opinions that are quite applicable, really, and the principles enunciated, it should really compel full marriage equality once adopted. So, I think at this point that we are definitely looking at being in the U.S. Supreme Court in a matter of, just a matter of a couple of years, and I think it will, in all likelihood, be a case that will present the full argument.
Yeah, you have a case, the appeal in Utah is in 2 weeks, and Oklahoma in 3 weeks, and Virginia 6 weeks or 8 weeks, whatever it is. Why should we not think that, you'll win there, it'll be appealed, and that's the case, that it's literally a race, say between Utah and the 4th District for getting there, and with the Supreme Court, these are all just going to be opinions from whoever wants to answer, but would we expect that they'd have to take first case that comes to them if it's a full-on case with a full-on appeal from the losing side? How do they sidestep that? Do they start to just let entire circuits go, like states have gone, like the 17 states have gone, and just let an entire circuit full of states have gay marriage and not grant cert? And then just quickly, a separate question: how much does each district court decision help the next? I don't mean literally the next, but all of these cases helped by Windsor and the language in Windsor and what Kennedy had to say, but does the momentum help, do you think, as these district court judges are making their decision? So I don't know who wants to answer either one, but
Speak to you. You're up first.
Sure. Well, as James was saying earlier, the Supreme Court has tremendous discretion and latitude to take whichever case it wants. I mean, the court recognizes the importance of this issue. They are fully aware that all these cases are emerging in the courts of appeal on approximately the same timetable. They're going to have a range of cases to select from. It's not, they're under no obligation, nor is it particularly likely that they're going to take the first case to be decided by a court of appeal. I mean, I'm fully confident they understand how important the issue is, and they will select a case that will enable them to address the constitutional merits of the question. And on the momentum, yes. I mean, I was thinking in response to your question earlier, I mean, we should not lose sight of what we heard earlier today about, I mean, this has been a dramatic shift in public opinion in a very short amount of time. That the fact that the first post-Windsor decisions, successful decisions, were out of Utah, Oklahoma, Texas, Virginia, Kentucky, Ohio, I mean, that speaks volumes about where the country is and where it's headed. So the momentum is there, and it's certainly on our side. And yes, every district court decision, especially from states that are considered to be more conservative, helps push the issue forward. I think if anything, we're in danger of losing sight of how much the country has changed. And all of the circuits, we could win in all the circuits. That is entirely possible.
Can I add one quick point? Sure. One of the questions that was important to us to address to Judge Friedman is, how do you know when you're at a tipping point? And there's language in Lawrence v. Texas that talks about that. And it talks about when there's an emerging recognition. And that ties in not just with change in public opinion, it ties in obviously with the momentum in the other cases. And it really helps to define the extent to which we are at, and now I believe past that tipping point. But it's not just an abstract question. It's a very specific legal question as well.
Take a couple more questions. Ariel?
Yeah, Ariel Gingold with Ben VR Jewish Action. So building off your comment on the tipping point, Ben VR has been on the briefs that have been put together for the religious community, which also focus on the religious liberty reasons that we should have marriage equality. And it seems like in the marriage realm in particular, we are really making gains in pushing back on the religious liberty argument. From your experiences, from your cases, what do you see, particularly with regards to the religious liberty challenges, that can inform our work going forward, both on marriage and also in some of the other related religious exemption cases that can inform our strategy and more?
We had testimony at our trial on the history of marriage as an institution that addressed that very specifically, and I think it's a very important point, and we continue to stress it. Judge Friedman addresses it in his opinion as well. Marriage is a matter of civil law, and as a matter of civil law, it is gender neutral in terms of the obligations and rights of the parties, which is an important part of why all this litigation is succeeding on an equal protection basis. And the point is that if particular religious authorities choose not to accredit or bless a particular marriage as part of their denomination, that's fine, that's an internal matter. It has nothing to do with what the law is. And the religious authorities have no right to impose on the law what marriage is, and the law has no right to impose on religious authorities which marriages they will choose to accredit. Of course, also note that there are a number of denominations that support marriage equality, but for those that don't, winning the legal battle for marriage equality does not intrude on their rights not to accredit. I happen to be part of an interfaith marriage that my wife is Catholic. I'm Jewish. Our marriage would not be recognized by the Catholic Church. That's a matter for the church. It's not a matter for the law.
You think that the religions, regardless of which religion it is, would recognize a marriage based on love?
Chris, I'll give you the last question.
I have a question for the Sixth Circuit people. Now that that circuit is the only circuit, I believe, where each state has a marriage equality case in some form or another over that circuit. They're not all quite the same thing, but I'm just wondering if you have any expectations that the Sixth Circuit will consolidate those cases into one as it goes forward, and that'd be a welcome development.
We're on the same briefing schedule as of Monday.
Yes.
So we're kind of anticipating that we may well be consolidated. We have filed a motion to expedite that hasn't yet been ruled on. It was Tuesday we got the briefing schedule, and we filed a motion to expedite on Tuesday along with the answer to the stay. But I would kind of be surprised if we don't get expedited, and you're in a slightly earlier briefing schedule, but
so we're the Ohio case is a little bit like about a month ahead in terms of the briefing schedule from the other 3 Sixth Circuit cases. I think it's a good bet that there will be one day when the marriage issue will be argued in the Sixth Circuit for all the cases. Maybe it won't happen, who knows, because it's their decision, not ours, but it's a good bet.
This would happen on the court's own motion, or will one of you ask for it?
TBD.
Great. Well, thank you all for joining us, and please join me in a round of applause for our great panel.